So the end of a tangled week of arguments, allegations and verbally combustible clashes with huge political implications on the back of inter-ethnic brushfires, even as the effects of the election season continue to be felt. 7 days of political flare-ups full of the grim realities of election disputes with those destructive inter-ethnic flames, political battles and legal challenges in the background. A week in which one civil society observer warned that more than 50 years after Nigeria's very incendiary civil war ended, the country is still behaving like a child with pyromania who relieves anxiety and draws attention by striking another match, lighting another fuse, and then sitting back and watching the pyrotechnics, and that it won't take much more than another spark of that tinderbox for the forges of discontent to flare into a big, bright fire. So how then to quench the flames before they burn out of control? Well, one way is through the courts, but can the judicial process be trusted to deliver? We'll look back at an extraordinary week of national political conflict, legal tussles, judicial swings, and a major international embarrassment for Nigeria. And for their perspective on the news and topical issues of the week, I'm joined now in the studio by the political commentator, Professor of Communications and Deputy Dean of the Postgraduate School at Bayes University in Abuja, Professor Abiodun Adeniyi, by the journalist, political affairs commentator and Arise News analyst, Dr. Constance Ikokwu, and the lawyer and Arise legal analyst, Chinwe Izegbu. Thank you very much indeed to all of you for being here this evening. And let me come to you first, Prof, so you don't feel bereft in the off-site studio there. Thank you very much indeed for your patience. So an appeals court sitting in Abuja unanimously deciding that Governor Adeleke is the governor of Osun State and that former Governor Boyega Oyetola failed to prove his case of overvoting. What's your reaction to that?
Well, the first reaction is that we are still having to go through the judicial process with respect to Osun, which is something we ordinarily expected, considering the regular result of political actors, to the judiciary most of the time when they lose elections. So it's a normal process, and of course, we're also expecting that the case was either going to go down or up. And in the first court of first instance, of course, gave judgment to the former governor, and now we're having that judgment reversed. It is also expected that it's going to get to the Supreme Court, so predictably it will go to the Supreme Court. But the interesting thing is that due process is being followed. This is diligent enough. That's the arm of government that we expect to intervene at this level. So, but it just speaks to the fact that the character of our democracy is not changing. It is still a way of saying that we are still concerned about, endless litigation. We're here to imbibe the culture of accepting defeats, irrespective, without prejudice to whether defeats are legitimate or illegitimate. We are here to accept that culture. And of course, maybe the winners too are yet to understand how to manage victory. But the development is quite salutary. I know we've not had the last of it. We're still headed for the Supreme Court in the case of Osun, like I said. But until the Supreme Court finally speaks, we will not say Osun election has come to a closure. But the downside of it really is that whether we like it or not, most of the governors who are involved in these are constantly distracted, from the most important business of governance, because governance is not for show, governance is for service delivery. Governance is for the provision of the anecdotal dividend of democracy. But we're having endless distraction that is nearly lasting up to 1 year. Where will the governors find that psychological, that mindset, to feel rested, to feel focused, and of course, concentrate in the most important business of statecraft. And that's why we're saying that endless adjudication may have to stop at some point in the future, once more, without prejudice, to the validity of the case that they're probably pursuing, the ability to accept sometimes, whether you think you are right, it speaks to the man in contestants, and of course it underlines the fact that we're probably growing in terms of culture in our democracy. Democracy is also part of culture building. Are we really building the culture of democracy? I'm afraid we are probably not, but some little mileage here and there, we will say we have achieved it, but we can achieve more rather than the slow work we are having in the present circumstance that we are in. Finally, from me, Charles, it's okay. We have appeal court speaking with respect to Osun. That's a good one, for the sitting governor. Now, I know we are headed for the Supreme Court. On the Supreme Court speaks on it, we cannot say a closure has come. Thank you.
Absolutely, Prof. Thank you very much indeed for that opening analysis. You made some very good points there. Let me come to you, Dr. Constance Ikokwu. The appeals court dismissing the decision of the election tribunal that annulled the election of Governor Adeleke. Does that give you confidence in the judiciary, or does it deepen your skepticism?
For many Nigerians, the judiciary sometimes has proven that indeed it can be trusted and that the public can confide in them with regard to the judgments that they give. At other times, they have fallen short. In the case of Osun, like Prof said, there still is a way to go in terms of the Supreme Court. That is if Oyetola decides to go to the Supreme Court. But remember that on this show, before the February 25th election, when you invited the former INEC officer, Mike Igini. Mike Igini painstakingly explained what went on in Osun and the tribunal. He did, even with a graph, say that the beavers, people misunderstood beavers, and that it wasn't a case of overvoting. He clearly said that, and he was convincing in his argument on that day. So now the appeal court has sort of come to the same conclusion that there wasn't overvoting in that election. I wish that, politicians will, at a point, stop continuing or stop the court cases and, accept the judgment of the court. Because like the Prof also said, that you need time to face governance. You need time to focus on the things that matter to the people of Osun State, to hit the ground running and, get the engine of government going. But, if they decide to go to the Supreme Court, so be it. And we will be watching to see what happens at that end.
Absolutely, and I do recall Mike Igini making those points that you referred to there. And let me come to you, Chinwe Izegbu. Thank you for being patient. Obviously, as we heard Prof say, we heard Dr. Constance Ikokwu there say, this is going to go probably all the way to the Supreme Court. Given, I don't know if you've really gone through the case, because it only just sort of came through today, the victory at the appeals court of Governor Adeleke. But I wonder what you reckon will be in the arsenal of the APC to contest the case at the highest court, given the things that Dr. Ikokwu just talked about, the references she made to the issue of beavers and the improbability of overvoting.
Yes, thank you, Charles. One of the most intriguing aspects of the judiciary is the ability of our courts, both in Nigeria as well as abroad, to judiciously interpret the statutes. Now, when I say judiciously, I mean the Court of Appeal has been able to interpret the Electoral Act today precisely, appropriately, and objectively in accordance with the principles of equity, fairness, and justice. I think this will, in many ways, restore the confidence that many Nigerians have in our judiciary. Having said that, Section 134 of the Electoral Act makes it very clear, Charles, that in order to succeed in bringing a petition at the tribunal or the Court of Appeal, as was the case today, the petitioner or appellant, which is Mr. Governor Adeleke, must sufficiently establish before the court that, one, he was qualified to contest the election, and two, that there were no malpractices, corruption, or falsified electoral results. And thirdly, more importantly, that he scored the highest majority number of lawful votes in the election. And today, the Court of Appeal set aside the tribunal decision based on that very ground, which says that he scored the highest number of majority of lawful votes. The Court of Appeal actually referred to the back-end server, saying that it was not sufficient for the appellant or the respondent to rely on the back-end server, that they must be read in conjunction and in combination with the beavers machine. So today, the Court of Appeal said very clearly that there was no overvoting because the combination of the data from the beavers machine and the back-end server came to the conclusion that there was no overvoting. I think personally, in my humble opinion, this has restored my confidence even more. I mean, as an officer of the court, I have confidence in the judiciary, in the Nigerian judiciary, but more particularly today, because most people would have thought that the court would have probably had a decision in favor of the APC governorship candidate, Oyetola. But it was not the case. The Court of Appeal actually gave a decision in favor of the PDP governorship candidate, Adeleke. So we are making significant progress here, Charles.
Well, thank you very much indeed, Chinwe. And I mean, of course, you are a lawyer and you are a RISE legal analyst. So I'm glad you forensically went through what transpired in court, and very enlightening your analysis there. Thank you ever so much. And Prof, I wonder if, like Chinwe, this decision has given you the confidence that the legal process when it comes to election-related litigation is likely to go reasonably fast, because, I mean, this has taken fairly, it's been fairly quick going through up to this point.
Yeah, Charles, first I think it's quick because there are times specified in which for these cases to be resolved, so I think the courts are probably trying to work within time, and of course they are meeting the schedules, as the case could be. But my first preference actually would have been that we'll grow our democracy to the extent that we could resolve issues largely at the ballot and not necessarily resorting to what one of the legal minds called tribunalization. Not necessarily taking on the third cause, which is the judiciary. But because by the time we go to the judiciary, of course, most of the time we are at the mercy of the cold facts of law. And of course, we do know, that legal justice is not the same thing as social justice. And sometimes there can be a question of, legal determination of these processes, and of course, robbing us of the legitimate determination of holders of electoral offices. So these questions might arise. And what about the question of us getting justice, but again, justice denying us of what the truth could be. So ordinarily, I would have wanted a situation where our electoral process will grow to an extent where a large portion of, or a large number of participants will feel a sense of satisfaction, with the outcome. And this rests largely at the doorstep of the umpire, the INEC that is, and of course the security agencies, if they can be above board. I know this is a tall order, but if we continue to work painstakingly at it, slowly we're making progress, but the argument is that the progress is rather too slow. We have everything in our hands that should have made us to progress much more than we are doing. But again, to your question on the judiciary, I do not have any option other than to trust those gentlemen, legal minds. I believe that they are accomplished citizens. They have paid their dues over the years. It's not a joke to be a Supreme Court justice, for instance, or a justice of the Court of Appeal. So I want to trust that institution, beside the fact that it is a critical institution implicated in the democracy. It is one important arm in the Trinity, the legislature and the executive being the other one. But again, questions of distrust around them have arisen over the years because we have seen some shock judgments. And of course, the shock judgments, that run counter to public opinion, social expectations. But of course, lawyers will always tell us that it's not necessarily about expectations, it's about the core facts of law, about technicalities. And can you deny this? Can you dispute this? Of course we cannot. The only way to avoid it is to probably make sure that the processes are clean, and probably for us to grow our mindsets in electoral contestation such that we can be gallant if we lose, we can feel a sense of satisfaction that we have participated at all and no resort to tribunalization. Because by the time we tribunalize it, it's now going away from the will of the people, from the wish of the people, to the dictates of black letter law, the specifications and the interpretative ability of the justices, who are comparatively few when compared with the number of voters that will have spoken in the first instance. But again, we do not have any option overall, finally, but to continue to trust in the institutions of government, because one of the bane of our development is the fact that our institutions are there, but we do not respect them. And because we do not respect them, individuals now want to assume the role of institutions. But we know that nations grow through the instrumentality of institutions. Our judiciary is a critical institution. We have to trust them because it's a channel through which frustrations, disappointments, irritations can be ventilated. And that is even more so in the political environment, where contests, where individuals can be very vociferous, largely die-hearted, as we are seeing in some circumstances now, even though we cannot question, even without prejudice, to the points that they are making. But overall, we are concerned about building a culture and making sure that that culture is civilized, elevated, and top-notch.
Prof, thanks very much indeed. Let's shift gears slightly now, because as I'm sure many people must have heard, Nigeria's former Deputy Senate President, Ike Ekweremadu, and his wife Beatrice were found guilty on Thursday in London of what the Chief Crown Prosecutor called the horrific plot of exploiting a vulnerable victim by trafficking him to the UK for the purpose of transplanting his kidney. Let me come to you, Dr. Constance Ikokwu. What do you reckon has been the reaction? Because we heard about reaction in London. A lot of people are appalled by all of this. But what's been the reaction to Mr. Ekweremadu's guilty verdict here in Nigeria from the assessment you've been able to make?
The reaction has mostly been that of shock in some areas. And some people are really shocked that this has happened. It's like the mighty has fallen. Whichever way you look at this story, it's completely disastrous for the families involved, Ekweremadu and his family, for the boy that was exploited, and for Nigeria with regard to our reputation. It's really tragic, especially because the person we are talking about is a high-ranking, or was a high-ranking member of the Senate in this country. And if you permit me, I want to read quickly some of the judgments that was given in court. You know, the judge did say that the organ donor was treated as a disposable asset and the spare part. And he also went on to say that the Ekweremadus agreed to reward someone for a kidney for his daughter, somebody in circumstances of poverty and from whom he distanced himself and made no inquiries, and with whom for his own political protection he wanted no direct contact. In fact, so what the judge is essentially saying here is painting a power dynamic between the Ekweremadus and this 21-year-old man who was picked from the street. You then wonder how someone of his caliber and standing could get into this kind of mistake. The story, as we all know, was that this man was picked up from somewhere and railroaded into London to do this. There are so many other ways, legal ways and proper ways to get an organ donor for a sick person. I mean, some people are, you know, sympathetic with their Ekweremadus that their daughter is sick and needs help. Other people are also saying, well, you have been in the Senate for at least 20 years as a lawmaker. What have you done in Nigeria to help in terms of health, setting up health facilities for the country? Oh, well, you have the funds and the resources to go off to London like many politicians do and many public officers to take care of the health of their families. What about those of us that are in Nigeria that do not have that kind of fund to do so? So some are sympathetic, others not so. But it is terrible for the image of our country. And you can see that the trial was speedy. Within 6 weeks, the judgment has already been reached because they really wanted to wind this up. Right. So that's another lesson, you know, of, you know, in terms of how fast judicial cases can be. Absolutely,
and I think you made a good point there when you talked about Nigeria's healthcare system. That if it was working, Mr. Ekweremadu, who's been in government for 2 decades, would not have had the need to seek help abroad. So in a sense, he is, to some extent, by some people at least, seen as complicit in not fixing that healthcare system so that he would not, or anybody in fact, would not have to travel abroad. But let me come to you, Chinwe Izegbu. You are a lawyer, of course. Senator Ekweremadu has been a contributor to the making of laws in Nigeria, one of which I understand prohibits human organ trafficking. So how astonishing is it that he himself is now guilty of organ trafficking?
It's very ironical because I was very shocked by the verdict. Having said that, Mr. Ekweremadu was actually in charge of the legislative arm of the National Assembly as the Deputy Senate President when the legislation was made at the time, that is the corresponding legislation in respect of human trafficking in Nigeria. So he probably was not aware of the interpretation of that statute. So we have it again that the courts have the exclusive right and jurisdiction to interpret a statute. So even though Mr. Ekweremadu was at the National Assembly at the time when the law was made in Nigeria, he went over to the UK not being aware of the legislative statute which prohibits human trafficking in the UK. Now, Section 2 of Modern Slavery Act in the UK, I think it is 2015, prohibits anybody from facilitating the journey or travel of anybody to the UK with a view to exploiting that person. The key word, Charles, is exploiting. So the court took a dim view of the fact that this young man, 21-year-old, as we now know, was exploited. Mr. Ekweremadu is a compassionate, loving father, and like every loving father would do for their daughter, he did what was best for his daughter. notwithstanding the fact that he was acting in contravention of Section 2 of that statute in the UK. Just one more thing, Charles.
Briefly.
The court actually convicted Mr. Ekweremadu of a summary offense, which means that the sentence is 12 months imprisonment maximum, or a fine, or a combination of both. So by the time he's sentenced in May this year, he would have served at least 12 months imprisonment. So that it is not an indictment. An indictment attracts a more severe penalty of life imprisonment. That does not apply to Mr. Ekweremadu.
Okay, well, that's an interesting interpretation, and I mean, we obviously trust your legal analysis there, because we've heard different things from different people, but you're the one who's got the legal experience here. I'm going to come back in a minute and come to you, Prof, because I want to finish this section of the Ekweremadu issue off, but before we do that, we've got to take a break. You're watching Arise Prime Time, plenty more still ahead as we continue our assessment of the big political issues of the day and the week. Stay with us. Welcome back to Arise Prime Time. I'm Charles Eniegolu, and as we continue our look back at an extraordinary week in Nigerian politics, we return straight away to informed analysis that makes sense of the big issues and distills with clarity Nigeria's topical political developments so you can see the full picture. And still with me to help us with all of that, the political commentator, Professor of Communications and Deputy Dean of the Postgraduate School at Bayes University in Abuja, Professor Abiodun Adeniyi, the journalist, political affairs commentator and Arise News analyst, Dr. Constance Ikokwu, and the lawyer and Arise legal analyst, Chinwe Izegbu. And before we went on the break, gentlemen and lady, we were talking about Nigeria's former Deputy Senate President Ike Ekweremadu and his wife Beatrice, who've been found guilty in London of what the Chief Crown Prosecutor called the horrific plot of exploiting a vulnerable victim by trafficking him to the UK for the purpose of transplanting his kidney. And I'm going to come to you in a minute, Prof. But just before we do, I need Chinwe Izegbu, who's our Arise legal analyst, to clarify a point for us. Senator Ekweremadu, of course, has been found guilty under British law. Is he likely to face charges under Nigerian law?
Well, there have been various different suggestions as to whether he will face another punishment if he does arrive in Nigeria. The case of double jeopardy comes to mind. What I would suggest is that the law enforcement agencies will determine whether or not he should face another prosecution under the Trafficking of Persons Prohibition, Enforcement and Administrative Act, which is actually the statutes, the corresponding statute here in Nigeria, which prohibits exploitation of workers in the form that the UK government or the UK judiciary has stated. In particular, Section 369 of the Criminal Code Act in Nigeria prohibits that offense. The maximum term of punishment is 7 years, minimum 6 months under the Criminal Code Act. So it is actually up to the law enforcement agencies to determine whether or not he will be prosecuted again on arrival.
Okay, thank you very much indeed, Chinwe Izegbu there. And Prof, thank you for your patience. Let me come to you. How much of an international embarrassment is all this for Nigeria?
Well, Charles, I'm not sure. Yes, it might be disturbing at the level of branding, at the level of public relations, but I'm not going to be too bothered about that because nations fall in and out of crisis, and sometimes it can be at the individual level, sometimes it can be group level, sometimes it can even be at the bigger global level, you know. So it doesn't really matter. It's just that the senator found himself in an unfortunate situation. Any parent will actually go for broke, try to take care of a loved one, and he tried to pull all these stops, you know, to take care of an ailing child. You know, it's something that a responsible parent would do. Just that he found himself, his attempt to help the child, you know, in UK implicated the crisis of jurisprudence, you know, and of course that was a culture that was already imbibed here, where oftentimes we just think we can take things for granted, but those things they'll probably take for granted in some other crimes they take very seriously, and that's why the senator found himself in this matrix. Otherwise, there are probably other countries that he would probably have gone to, you know, to seek the medical attention, and he probably wouldn't be in this kind of controversy. Not that unfortunate. We sympathize with him at this point in time. Really, if it was possible, we just ask the judiciary in the UK, you know, to have compassion in him, to forgive him and just let him go, considering the trauma he has gone through, irrespective of his status. But again, the lesson we have to draw from it is what some of my colleagues have pointed at. That is probably a reminder for us, or a reminder of the state of our own health, you know, the state of our own health facilities. Because, you know, the health system in the UK, you know, where it was developed by men, you know, who were conscientious about national building, about national growth, about strengthening their institutions. And that's why UK is a prominent medical destination for citizens in Africa and not just Nigeria. So if it can be done in the UK, why can we not replicate it here? So it's a time for introspection. Perhaps we need to just replicate some of these structures, some of these facilities and infrastructures that we'll go to enjoy in other climes. And of course, if that had been done, you know, this implication or these differentials in the character of jurisprudence will probably not be coming to fore. Then finally, of course, again, it's also very important for us to re-emphasize this point that we could see the nearly mathematical precision, you know, that the trial went through in the UK. Very much unlike our situation where by now, you know, may just be endless preliminary objections, back and forth and all of that, all in a bid to frustrate the case. Now, within a year, he's able to know his fate, even though it's unfortunate. And that's why we're saying that at this time, we probably simply should be drawing lessons from it, even while asking that, you know, in passing the judgment at the end of the day on him, you know, we need compassion, we need sympathy. You know, he needs sympathy. And of course, if it was possible, we just say, can you just let him go and ask him to sin no more? Because he found himself in an unfortunate situation, but the lessons that we need to draw from there, that we need to take from there, should not also be lost on us, as the case could be, Charles.
Well, thank you, Prof. One thing I can assure you is that people in the West don't say, go and sin no more. They leap down on you from a great height when you've committed an offense, particularly if you're a significant public figure. In that case, there's no getting away with it, I'm afraid. But let's shift gear and rest that case for now and turn to the other big political story that happened in Nigeria here. Festus Keyamo, who is a spokesperson for the ruling APC's Presidential Campaign Council, has petitioned the Department of State Security, which is the equivalent of Nigeria's secret police, to arrest Peter Obi and Yusuf Datti Baba Ahmed of the Labour Party and to prosecute them for what he called claims capable of causing insurrection. Dr. Constance Ikokwu, let me put that question to you. What's your reaction to that? He wants them charged with treason.
When I read that story, was it yesterday or 2 days ago, I wasn't sure what to make of it. It came out of the blue, from nowhere. When we have been in the eye of the storm following the elections, you know, aftermath, fallouts, you know, a lot of brouhaha here and there. So when this man, Mr. Festus Keyamo, came with this petition to the DSS, it was like, what is this about? I mean, the man, you know, Keyamo really fancies himself. He talks a lot, talks way too much. And some people would say that he is probably trying to distract from the main issue. He has said that the Labour Party has made incendiary comments. His critics would also counter and say that the APC and its spokesmen have PhDs in making very incendiary remarks and commentary in this country. We have lived through it for the past 8 years. Festus Keyamo also is guilty of that. So are his other spokespeople. The point, though, at this time is that there is something to focus on. The Labour Party and the PDP were asked to go to court to challenge the results of the election if they did not like it. Now they have taken that step. They have filed their petitions before the Election Petition Tribunal, and we are waiting for that. So this is a big case in front of us. Many Nigerians want to look up to the judiciary. We have been talking about the judiciary in this program. What are we going to get from this judiciary? Is it going to be a judiciary that sometimes exhibits some form of rascality in the kind of judgments that they give? Will it be a judiciary where the highest bidder can purchase judgment that is favorable to them? And everyone is looking and keen and watching to see how this plays out. Some have said that, in fact, this case should be covered live so that Nigerians can follow every bit of it. So it's a big one. So what Festus is saying is a distraction as far as I'm concerned. The other thing is that if the DSS eventually decides to arrest the Labour Party candidate, Mr. Peter Obi, I think that would be a crisis of major proportions. But let's see what happens.
Yeah, that's a good point. And that brings me to Chinwe Izegbu, because obviously, most people would say that it is most unlikely that the DSS would make such a move. But if they did, just following up on what Dr. Constance Ikokwu was saying there, how much would the lid be let off the gunpowder, as it were, if that happens?
The inflammatory comments by Mr. Festus Keyamo was very, very surprising, actually. To say the least, because treason is a very serious offense under Section 37 of the Criminal Code Act. Treason is an offense that relates to a person who levies war against a federation, such as Nigeria, or levies or conspires to do so in order to intimidate a president of a nation. Now, I don't know whether he was referring to President-elect Bola Tinubu as the person that is on the receiving end, or if he was referring to President Buhari. Whatever the case is, it is not easy to prove treason in a court of law. You have to have compelling evidence, sufficiently compelling evidence to convict. So as to make such inflammatory remarks at this time, when Mr. Peter Obi has actually resorted to the Court of Appeal to seek redress, which is his constitutional entitlement, I think it is actually over the top. It is most inappropriate, to say the least.
Okay, thank you very much indeed, Chinwe. And Prof, do you see this call for the arrest of Peter Obi and Dati Baba Ahmed as a marginal act, as some have suggested, or as a key provocation?
Well, Charles, the gratifying thing is that agencies of government hardly act on the basis of pressure from individual, even when it's at the level of the groups. I doubt if they often. I've never had a time where they responded because somebody wants something to happen, especially when there's no clear-cut evidence. Most of the time, they act on the basis of their own painstaking investigation, and when they think that there's a reason for somebody to be apprehended. They do not act just because an individual or a group of individuals feel that something should be done. And having said that, it comes back to the point I made that We just need to be much more tolerant of ourselves. You know, there are two key rights, two key things that are central to democracy. And maybe I should first of all say that democracy sometimes is not really about the tangibles, you know, that will produce from it, maybe infrastructure, utilities, and some of these benefits that we'll talk about. You know, the most important thing about democracy is about representation and inclusion. Representation and inclusions of fragile entities, communities, peoples, etc. And that representation also includes, you know, ideas, notions, you know, thoughts of people. And those thoughts can come in different shapes, in different sizes at any time. So what we need to do is just to be tolerant, you know, of these exchanges. You know, it doesn't matter how you feel somebody has made his or her statement. You know, what matters is how you receive it. Somebody can say something very strong, and you decide to regard it as a mere expression of his own opinion, which he has a legitimate right to. So you do not necessarily have to be provoked and say, oh, somebody has said something, and you consider it, you begin to label it, use adjective to describe it, and you want to take another step or one step or any other step for that matter to deal with the person. You know, that's not democracy. That's not the philosophy behind you know, the democratic dispensation that we want deepen in our client. That's the culture I think we should deepen. You know, we should be much more tolerant of ourselves and be concerned about calming frayed nerves in a post-election period, considering how close the elections were. And of course, when we have a close election like this, you expect that the tension that will come after the declaration of results will be very frenzied. And when you see that kind of atmosphere, what you need to do is not to overheat it further with threats and counter-threats, but rather trying to assuage the feelings of people, you know, who probably feel cheated. And of course, feeling cheated is something that they too have rightly taken off through the instrumentality of the court. So since they have resorted to that, all we need to what we need to do going forward is just to have mutual understanding, mutual tolerance, feeling again that we are probably going through a period of catharsis, a period of rationalization, you know, a dumbing down system, a period where matters will peter out, and then again we'll be back on track. You know, so otherwise, I don't see any reason why we should overheat or overbeat what shouldn't matter in the first instance, Charles.
Okay, Prof, thank you very much indeed. And we've got about 5 minutes or so left on the program. So I would really like to go round and get each person's assessment of this next story. So if we could all be reasonably brief, that would be much appreciated. The story, of course, the PDP baring its fangs, to borrow a term from This Day newspaper, and suspending Ayo Fayose, who was a former governor of Ekiti State, as well as a former Senate President, Pius Anyim. It's also dragged Governor Autumn of Benue State before a disciplinary committee, all of them under attack for anti-party activities. Your thoughts on that, Dr. Constance Ikokwu?
This was coming. Former Governor Autumn publicly supported Labour Party candidate Peter Obi. I mean, he didn't do it in hiding. He came out, you know, with his chest and said, this is the person I'm supporting. This is a historical time in our country. We should work with individuals and not parties. You know, he did that. I think he might have also lost his senatorial bid because of that. Then Pius Anyim, in his state, he also supported the Abga governorship candidate against, you know, his own party. So that's there. And then you have Ayo Fayose, who also at the presidential and governorship level supported the APC. So you have it right there. The PDP might be, you know, it has the grounds clearly to you know, sort of send them away or, you know, penalize them for what they have done. We don't have much time, but right, these are my views briefly on that.
Thank you very much for keeping it nice and brief. And Chinwe, Izegbu, you have to wonder why the PDP didn't wield the big stick, as it were, before, not after the election, when it might have helped them draw the line under the corrosive anti-party activities of the likes of Governor Wike and his G5 supporters.
Yes, Governor Wike actually got an injunction order to restrain the PDP from suspending him. So I think he had a fair share of that deal. The others who have now been penalized by PDP are subject to the rumblings and political shenanigans within the PDP. We can only just wait and see what happens, Charles.
Chinwe, thank you for keeping that brief. And a final word from you, Prof. I mean, is this a case of shutting the stable door after the horse has bolted, trying to prevent something from happening, but doing so too late to prevent damage being done?
Well, it's very unfortunate. I think the PDP hierarchy is probably just reacting because so they'll probably not be seen as weak or tepid. You know, it's a reaction that does not have much meaning because the people that you are sanctioning don't really care anymore. They've made up their minds. One of them even said he's no longer in partisan politics or he's no longer a member of the PDP, and you are sanctioning it after the deed has been done. So it doesn't really matter. What I think the group should do now is to be thinking about how to bring about, their fractured enclave, how to ramp up their collectivity once again and become a strong party, the strong party that we used to know them as. And this is probably not the time for sanctioning, for punishment, etc., because if they continue like this, they will do more damage to themselves than any good at all, Charles.
Okay, on that note, Prof, thank you very much indeed. Professor Abiodun Adeniyi is, of course, a political commentator, professor of communications, and deputy dean of the postgraduate school at Bayes University in Abuja. And thank you also to the journalist, political affairs commentator, and Arise News analyst, Dr. Constance Ikokwu. And last but certainly not least, a very big thank you to the lawyer and Arise legal analyst Chinwe Izegbu. That's it for this edition of Arise Prime Time. Join us again next week. From me and the entire team here in Abuja, bye-bye and thank you for watching.